Well, Dean, thank you very much indeed for that very warm welcome. A huge pleasure, as always, to be here at Policy Exchange, and honoured to be here with Alexander, who, of course, has a distinguished record down under in Australia, where, of course, the government, back in about 2013, very successfully undertook a task rather similar to the task we have to undertake in the future. Dean, thank you also for the work Policy Exchange have done in this area, including your Judicial Power project. Thank you for that, and please keep up the good work. Now, let me start with the very sad story of Rhiannon White. Rhiannon was just 27 years old and worked in an asylum hotel. On the evening of 20th of October 2024, Rhiannon had finished her shift and walked to a nearby station to get the train home. She was followed by Deng Majek, an illegal small boat immigrant from Sudan who had entered the United Kingdom 3 months earlier. He attacked Rhiannon, stabbing her 23 times and tragically killing her. I've met Rhiannon's mum, Siobhan, and she has said this to me: "It's not fair that an illegal immigrant could come into the country and do this to my daughter. Why doesn't the government stand up and do something?" Well, I think that's a very good question. Cases like Rhiannon's are why public trust in the government on immigration is so low. The government has not stopped mass channel migration. Over 73,000 have crossed since the election, more than under any other Prime Minister. Every time a new rape or assault by an illegal immigrant is reported, public trust goes down further. Such as 3 small boat migrants gang raping a woman on Brighton Beach, a 12-year-old girl in Nuneaton raped by an Afghan illegal immigrant, a woman in Hyde Park raped by an Egyptian illegal immigrant who was also a convicted Islamist terrorist, a 14-year-old girl in Epping sexually assaulted by an Ethiopian illegal immigrant, and of course Stephen Ogilvie in Belfast, almost beheaded last week in broad daylight by a Sudanese illegal immigrant. The list goes on and on. And the public is equally unhappy that likely well over 1 million people are in this country illegally. The problem extends to foreign criminals. While foreign criminals are deported in quite large numbers to European countries like Albania, Poland and Romania, relatively few non-European criminals are deported. Last year, for example, only 110 foreign criminals were deported to Jamaica, Iraq, Nigeria and Somalia put together, despite there being over 10 times as many prisoners from those nationalities in prison and many more out in the community. In fact, there are now 20,000 serious foreign criminals who have been sentenced for over a year in prison, but who are now circulating on our streets after release. Every single one of those is a risk to the public. The consequences can be fatal. Convicted criminal Ernesto Elliott was due to be deported back to Jamaica, but he was removed from the flight following a human rights claim. A few months later, Elliott murdered 35-year-old Nathaniel Awu-Agu in southeast London. If that deportation had gone ahead, then Mr. Awu-Agu would still be alive today. And even when an asylum claim fails, other legal challenges often prevent removal. So last year, only 12,000 failed asylum seekers left the UK, even though 80,000 applications were rejected that year. The failure to grip immigration is undermining trust in democracy itself. People vote for illegal immigration to be ended. They vote for foreign criminals to be deported. And yet it doesn't happen. This situation is completely unacceptable and it must change. Mainstream political parties must now have the courage to take the radical steps needed to fix this, or the public will turn away from the mainstream. We must start by asking why this issue has not been fixed. The truth is this: politicians are not properly in control of the immigration system, the courts are. The lack of parliamentary and ministerial control of the immigration system is undemocratic. Radical and sweeping change is needed to end the tyranny of the courts and restore democratic control over immigration. Because over the years, Parliament has allowed the creation of a legal system that hands near unlimited power to judges to decide individual immigration cases and the power to shape how the whole system operates through case law. And judges have used that power over time to make the system more and more permissive. So illegal immigrants and foreign criminals often cannot be deported. The consequence is that the UK becomes an attractive destination for illegal immigrants. I want to examine exactly how this has happened. First is the ECHR. Lord David Wolfson KC has brilliantly exposed how the ECHR, implemented domestically by the Human Rights Act, prevents effective border control. The way judges in the UK have interpreted the vaguely worded ECHR clauses is often more expansive than their European cousins or even the judges in Strasbourg itself. That is possible because the ECHR articles are necessarily very broadly drafted. For example, Article 3, which says freedom from torture, inhuman and degrading treatment. Now, that was originally written to mean don't send people to concentration camps. And nobody would argue with the clause as it's drafted, or would argue with it if it was reasonably interpreted. But the problem is it's now interpreted in a way that is unreasonable. Judges now say that inhuman treatment includes sending an Iraqi drug dealer back to Iraq because apparently he had become, quotes, too westernised. It is now also considered to be inhuman treatment to send a convicted paedophile back to Zimbabwe because as a paedophile he might face hostility in Zimbabwe. The court gave no thought whatsoever about the rights of British children to be protected from that paedophile or the right of the democratically elected parliament to decide who stays in this country. So these criminals were allowed to stay in the UK. In my view, that is totally unacceptable and it has to end. And because the ECHR sits above national law and is given full domestic force, including in our courts, by the Human Rights Act, there is very little Parliament can do about its effects. Even where Parliament legislates, individual decisions then risk getting injuncted by the court if the court considers them to be ECHR incompatible. It has anyway been the policy, in my view wrongly, of successive governments to almost always legislate in a way that is compliant with the court's expansive interpretation of the ECHR. And I remember vividly, as a minister a few years ago, designing what is now the Nationality and Borders Act. I wanted to raise the asylum threshold to make it harder to get asylum, so only people who could clearly prove they were at risk of being persecuted would get asylum, which is not how the system works at the moment. But I was advised, and I got external legal advice, I didn't believe it when I first heard it, I was advised that while I could change our domestic asylum law, there was no point in doing so, because migrants would simply make the same claim under ECHR Article 3, and the judges would grant the claim by applying a similar criteria to current asylum policy. So, as an elected minister, in a government with quite a big majority, I couldn't legislate through Parliament to have the effect I wanted, even if I could get Parliament to vote for my legislation, because of the way the ECHR operated. Then we come to modern slavery. Tony Blair signed up to the ECAT Treaty in 2007, and the 2015 legislation which followed it is all very well-meaning. It's designed to stop people being abused. But it's so generous that it allows foreign citizens with what they call reasonable grounds to say they're modern slavery victims to avoid or delay deportation. The threshold for establishing that claim is extremely low. A plausible sounding claim with no evidence whatsoever gets accepted. And as a result, tens of thousands of people, illegal immigrants and foreign criminals, have successfully used modern slavery claims to prevent or substantially delay deportation. And then we come on to asylum claims. Almost all small boat illegal immigrants claim asylum, and from countries like Sudan, Eritrea, Syria and Afghanistan, almost all applicants eventually get asylum. So no wonder so many people from those nationalities leave France, a safe country, and illegally enter the UK. The evidence needed to establish an asylum claim is laughably low. Some people claim to be Christian, often purporting to convert after arriving in the UK, and very often that is signed off by a well-meaning but misguided vicar. Many applicants claim to be gay, or if they inconveniently have a wife or child, or in one case had been convicted of raping a woman, they claim instead to be bisexual. Some, claiming to be dissidents in their home country, only joined an opposition group in their home country after arriving in the UK to help their asylum claim, advised, of course, by their immigration lawyer. But this nonsense has all been accepted by the courts. Many of these human rights, modern slavery and asylum claims are made in very similar forms, often only being made after advice from an immigration lawyer has been received. All of that is funded by immigration legal aid, with funding lawyers who sometimes advise illegal immigrants to fabricate plausible sounding but made up claims, which was recently exposed by the BBC to their credit, who secretly recorded the associate of an immigration lawyer advising illegal immigrants to fabricate claims to be gay or domestic abuse victims in order to stay in the UK. And they did that because they knew the legal system would simply accept it. It gets worse. You can make multiple claims over time, so the whole circus can be dragged out for years and years and years. I recall the notorious case of Yaqub Ahmed. This man was a Somali illegal immigrant who violently gang-raped a teenage girl. After his prison sentence, the Home Office, quite rightly, tried to deport him back to Somalia. But over many years, Mr. Ahmed made multiple asylum claims, human rights claims and modern slavery claims before finally being deported in 2023. But it took 8 years to deport a man who had gang-raped a teenage girl. And there's always judicial review as a last resort for the courts to stop someone being deported or to challenge a government policy. Then we come to the immigration tribunal itself. After the Home Office has made a decision, it can be appealed to the first-tier tribunal. Now, the waiting time for an appeal is now over a year, and there are 150,000 cases before the tribunal. And if the immigrant doesn't like that decision, they can appeal again to the upper-tier tribunal instead, which takes another year. And if that claim gets dismissed, they can just make another one and start the whole process again. Some of the judges who make decisions on the tribunal are themselves extremely suspect. A number have previously been or supported open borders campaigners. Immigration tribunal judges have previously worked for open borders groups like Asylum Aid, Refugee and Migrant Justice, Refugee Action and Safe Passage UK. Needless to say, those organisations have no interest in border control whatsoever, as their names imply. Given the evident biases of some tribunal judges, it's no surprise they've made some extraordinary decisions. For example, Judge Hugo Norton-Taylor handed down a judgment using ECHR Article 8 to allow Palestinians to enter the UK to join family members here, despite the government expressly having decided to create no such route. A Ghanaian criminal, deported 12 years ago, was allowed back into the UK, again using the ECHR, claiming he felt depressed back in Ghana. A Nigerian armed robber, who a criminal judge found presents, and I quote, a high risk of serious harm to the public, won an appeal against deportation back to Nigeria because apparently the mental health system in Nigeria is not as good as in the UK. Another immigration judge allowed an Albanian burglar with 50 convictions, 50, so he probably committed more like 500 offences, given how low the conviction rate is, but 50 convictions to stay in the UK because apparently that offending was, quotes, not very extreme. So if your house gets broken into by an Albanian burglar, you know which judge you can thank for that. These cases show immigration tribunal judges handing down decisions that fly in the face of common sense, but they are enabled by the current system. This is an insult to the British public, and it has to end. Given the thicket of opportunities to prevent deportation, it is perhaps no surprise that 93% of small boat illegal immigrants get to stay here, so no wonder they cross in the first place. And the numbers of foreign criminals deported to countries outside Europe is so small. So what is the solution? I've come to the conclusion, having studied this for quite a few years now, that only radical action, really radical action, will return control over the immigration system to Parliament and take control away from the courts. First, we need to leave the ECHR and repeal the Human Rights Act in its entirety. Now, in doing this, we should not replace those instruments with a domestic version, because a British Human Rights Convention or British Bill of Rights would necessarily be vaguely worded, just like the ECHR, And so the same problems of expansive and unreasonable judicial interpretation would arise. And Policy Exchange has written some excellent research making exactly that point. Now, most important and reasonable human rights are already in domestic law or common law. But if Parliament feels there is a gap in domestic rights, of course, Parliament can legislate to fill the gap. But it should do it in precise and detailed terms so that we can't have this problem with open-ended and unreasonable judicial interpretation. Now, the Labour government says they're going to tinker with the definition of Article 8. That's their solution, but that will make no real difference whatsoever. It was tried in the past, I think by Theresa May, and it didn't really survive contact with the courts. They also point to discussions at the Council of Europe about reforming the ECHR as a whole, but that will require 46 member states to unanimously agree, and it will also require the Strasbourg court, which is stuffed full of human rights aficionados, to agree, and in my view, there is no chance of that happening at all. In fact, in supporting that argument, Lord Hermer himself, the Attorney General, actually admitted as much last September to the Lords Constitutional Committee when he said reforming, changing the ECHR was simply, quotes, a political trick. That is literally the only thing Lord Hermer has ever said that I agree with, but on that point he was actually right. Now, human rights advocates like Keir Starmer claim that leaving the ECHR would mean we can't cooperate with other countries on migrant returns and other issues. Now, that is clearly nonsense. Most countries we need to return illegal immigrants and criminals to are outside Europe and aren't even in the ECHR themselves, and plenty of European countries who are ECHR members quite happily cooperate with the USA, Canada, Australia, New Zealand, and many other countries, none of whom are in the ECHR, and all of whom are perfectly respectable. So the government's argument about international cooperation is clearly nonsense. Secondly, we need to radically reform the asylum system. Illegal immigrants, like the Sudanese man who committed the Belfast attack last week, should simply not be able to claim asylum at all, period. No asylum for illegal immigrants. Illegal immigrants should instead be rapidly deported. And where we do allow an asylum claim, the bar for accepting it should be high, with real evidence of a genuine risk of personal persecution, by which I mean things like threat to life, imprisonment or torture. I do not mean day-to-day inconvenience, a less generous welfare or health system, or requirements for military service. None of those things, in my view, amount to persecution. Now, we can implement that change by amending domestic legislation, and outside of the ECHR and without the Human Rights Act, there is nothing the courts could do to override that as they do today. Thirdly, of course, we need to end the right basis of modern slavery claims to allow people to stay in the UK. That will mean leaving the ECAT Treaty and changing the Modern Slavery Act and other bits of domestic legislation. A modern slavery claim should not prevent an illegal immigrant or foreign criminal from leaving. Fourthly, we will completely abolish the Immigration Tribunal and completely abolish immigration legal aid. Immigration decisions should be made by the Home Office with a quick internal appeals process. Applicants should simply present the facts of their case. A decision will be made. The assistance of external lawyers who have been known to coach the applicant to lie, as the BBC recently exposed, will no longer be required. And finally, judicial review of immigration decisions and policy should be severely curtailed. Judicial review on the grounds of irrationality, sometimes called Wednesbury unreasonableness, procedural impropriety, which often means things like not consulting properly, allegedly, or the supposed legitimate expectations of the illegal immigrant should all be excluded or ousted as grounds for judicial review. But I do accept we need a guardrail of some kind. So as a safeguard, judicial review of immigration decisions would be allowed only on the narrow grounds of vires. That is to say, the government is acting outside its statutory powers. For example, the government should obviously not be able to apply immigration powers to British citizens or those with the lawful right to be here. And I accept the court should be able to step in and prevent that if it was attempted. Now, I estimate the measures I've just set out will remove about 98% of current immigration cases from the court system. So it'll essentially remove the courts from immigration matters apart from those 2% of cases which would be judicial review on the grounds of vires. Now, as a further safeguard, in exceptional humanitarian cases, I do think the Home Secretary should have the discretionary ability to allow someone to enter or to stay, but the use of that power should be discretionary and should not be open to judicial review. Of course, at times of international crisis, it would be open to Parliament to create a bespoke humanitarian entry route on a case-by-case basis. And in fact, this has actually happened 4 times in the last 10 years for Hong Kong, Ukraine, Syria, and Afghanistan. So, ladies and gentlemen, this set of proposals represents a complete departure from the approach to immigration law that has grown up over the last 40 years. It's a radical overhaul, completely changes it. But that is necessary because the system is so clearly broken. The public has lost trust. Elected politicians are being systematically prevented from controlling our borders. The truth is we have lost control, and half measures or tinkering will not get it back. These sweeping reforms will end control over immigration by the judiciary. It will return control to Parliament. It will enable democratically elected ministers to decide who can come to the UK and who can stay. The public will once again be able to decide through elections how the UK immigration system operates. And if the choice were mine, if I were Home Secretary, I would use these freedoms to deport every illegal immigrant, people like Deng Majek, who murdered Rhiannon, within a week of arrival to their home country if possible, and a third safe country if not. That would rapidly deter anyone from entering the UK illegally, including by small boat. I would also use these powers to ensure the deportation of all foreign criminals, not just some. I would ensure that over time, all those here illegally would be removed. At the moment, doing these things is virtually legally impossible, which is why successive governments of both colours have not done them. These sweeping reforms are critical to restore trust in politics, they restore parliamentary control, and they end the tyranny of the courts. It is now critical that mainstream politicians have the courage to make these radical changes, because if we don't, the public will turn away from the mainstream. The public rightly expects our borders to be controlled, and this plan will deliver it. Thank you.